Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing whether or not the federal government has absolute immunity from being sued by citizens hurt by unconstitutional laws. In a case that was just heard at the Supreme Court called R and Power, the Trudeau government argued that even if a law is struck down for being unconstitutional, people hurt by that law can never sue the government for damages, even if the law is clearly wrong, enacted in bad faith, or as an abusive process. The charity that I work for, the Canadian Constitution Foundation, intervened in this case to argue that this is wrong. The government must face consequences for unconstitutional laws, especially where it meets that high standard of clearly wrong, bad faith, or abusive process. And one of those consequences is monetary damages. But of course, not everyone agrees. Here today to debate this issue are two experts, my colleague Josh Dehaas of the CCF and law professor Gerard Kennedy. Thank you both so much for joining me today. Now, Josh, the issue in this case is a very narrow one. Whether or not the Crown has absolute immunity from a civil suit seeking charter damages for the enactment of unconstitutional legislation. The government says it does have absolute immunity, and Robert Power, who says he suffered damages as a result of an unconstitutional law, says otherwise. And we agree. We think that there is no absolute liability. Now, can you explain the argument here about why there should not be absolute immunity?
Sure. So before explaining why there shouldn't be absolute immunity, I just want to sort of explain why there's any immunity at all, because I think most people would assume that if the government breaches your charter rights through passing an unconstitutional law, that you would be able to get some money compensation for that, at least in some cases. But basically, the part of the charter that says that judges can award remedies for when your charter rights are denied or infringed is Section 24(1), and it says that judges can award what's just and appropriate in the circumstances. And this is very broad language. The court recognized from the start that this gives them a lot of discretion. It's whatever is just and appropriate. And early on, government started saying, well, it's not appropriate to award damages where we've acted in good faith and passed a law that we thought was constitutional, but that it later turns out, for whatever reason, was not constitutional and has been struck down. And courts bought that argument. They said, yes, we agree there should be some limited immunity so that you can continue to do your job. You don't have to worry about us later requiring you to be on the hook for these big damages awards just because you passed a law that later turned out to be unconstitutional. But courts also said from the start that that immunity is limited. It's not absolute. In cases where the government has acted clearly wrong, they've abused their power, or they've done something in bad faith, and people can prove that, damages should still be available. And we at the CCF agree that damages should still be available because sometimes that's what it takes to deter governments and stop them from doing the harmful things to your constitutional rights that they sometimes do. And sometimes that's the only way
Mhm.
to compensate people for the actual losses that they've incurred.
Now, Gerard, you disagree with our position. You agree with the Trudeau government's position in this case that there should be absolute immunity, even in these exceptional cases where there's bad faith or abusive process. Can you explain that position? Why do you think there should be absolute immunity?
Yeah, I guess I have principled and pragmatic reasons for it. On a principled level, all actors in the justice system are entitled to rely upon and follow legislation without financial liability. That isn't the case for the executive, but it is for the legislature. We've always accepted in Canada the remedy for unconstitutional legislation is declaring it of no force and effect, but it causes a lot of problems if someone who relied upon legislation and complied with it can be financially liable. We accept this is the case for federalism. If a provincial law infringes upon federal government power, the provincial government is not financially liable for that. And I think it's implausible that the charter mandated a departure from what otherwise remains a basic tenet of our legal system. I also don't know how you prove bad faith in a legislature, which is an incorporeal body. Bad faith is about subjective state of mind. having animus towards other people's interests.
Mm.
Does a single legislature matter? A substantial minority, unanimity? I just don't know how that's going to work.
We've got to go to break, but we're going to
Yeah.
continue this when we come back.
Yeah. Thank you.